whose credit information has been wiped, but they still cannot get credit. Don't go away. We'll be back right after this. Welcome back. We are discussing the credit information amnesty. MacDonald, one of the questions that is being asked, that is being said, is that the department and the NCR are not throwing the consumer in the deep end. They are going to issue affordability guidelines. In what form are those guidelines going to take?
No, thanks, Mr. Mateza. The guidelines have been published for consultation with stakeholders, including the banks, including consumers in the various forms. And therefore, they are encouraged to comment, not to stop the process, to comment and make inputs. And then guidelines are guidelines. So they will be guiding the credit providers, also the consumers. What information should I put to the fore in order to go for credit worthiness, removal of this impaired information in my records? So what should happen is that the affordability guidelines should one day, preferably, become regulations. Regulations, they are issued by the minister, and then it's not a voluntary issue. They will be binding. So guidelines is okay in order to build a culture of consensus, but preferably they should be moving to the issue of regulations, and regulations are not voluntary issues. They should be binding. If you don't follow them, then there will be a prosecution on reckless lending. Reckless lending is an offense.
Talking about reckless lending, shouldn't there be a code of conduct for credit providers, especially with regard to reckless lending and the way they advertise the credit that they give to consumers?
Yeah. Yes, correct. I think this issue of regulations, we are saying they should be binding, and then code of conduct, it should be informed by those regulations or guidelines, but they should be binding, because this voluntariness is the one that is leading to reckless lending, and therefore, if there is no enforcement by the courts, the NCR should approach the tribunal to say there is a reckless lending. They should refer cases to the tribunal, a credit tribunal, and then be binding. These issues of charter, I don't think it belongs here. A code of conduct that is not binding, it doesn't belong here. We are dealing with the lives of people and the economy of the country.
But Dollar made reference there to a tribunal. What role does the credit ombudsman play into this?
Well, the National Consumer Tribunal is the body that was set up by the National Credit Act, which is a court. And that body is one of the bodies, and you can go to other courts as well, to determine whether or not a credit agreement was entered into recklessly. The Credit Ombud is an industry body set up largely by credit providers, and really they are trying to assist when there's a dispute with a credit provider, and they have a legitimate role in that regard. But when it comes to disputes, for example, if you have a debt counseling dispute, then you should be going to the National Credit Regulator, because the National Credit Regulator is the body that's been set up by government to go and handle complaints and to take it on to the National Consumer Tribunal for a final decision.
We have been talking a lot here about what favors the consumer, I think, since we started here. But what recourse does the credit provider have?
Well, credit providers have the recourse of law. And remember that you're talking generally about very large credit providers, because well over 80% of all credit is granted by banks. And then you have very, very large credit providers as well. that take up most of the rest of the credit provider space or the industry. Only about 3% of credit extended goes to small credit providers who don't perhaps have a legal team or the expertise that a large credit provider would have. So in most cases, credit providers have significant expertise and good systems, and they are able easily to deal with the amnesty or any other proposals that government makes.
McDonald and both of you, Stephen, we've been talking about impaired information. What do we regard as impaired information?
McDonald maybe can comment after I've just explained the 4 categories of credit information. You have payment profile information, which is between 24 and 36 months of how you make payment. So whether you paid in July, if you didn't pay in August, that would be reflected in that 24 to 36 months of payment profile. It's also called account history information. Then you have adverse information. That's the information where an L or a W gets put into your payment profile, and it indicates that the account has been handed over or written off from an accounting perspective. And that is not limited to just credit providers seeing. That adverse information can be viewed by the public or by anybody that has been given access to your credit record. They don't have to be a credit provider. And then you have judgment information, which is the information from a court that a judgment was granted in regards to payment of a debt. And then the last type of information is notices like sequestration, debt counseling, administration, or rehabilitation. In this case, we are only talking about adverse information being removed on a once-off basis.
McDonald, do you probably want to add to that before we sort of sew up our discussion?
No, I think Steve has summarized very clearly, and then I don't think there is any addition. That is the adverse information we're talking about. But credit profile will remain in so much that therefore one can still make a judgment based on the credit information, but that adverse information has to go if necessary payment or potential of paying in the future can be shown.
Well, that's a mouthful that you've had here, Stephen, and thank you very much for having come here to us and explain this very difficult thing. I think there's still a long way to go between yourselves and McDonald. Have to work and try and get everybody else on board, and it's going to be a tough job to do.
We're trying.
Provided that the proposed credit amnesty takes adequate measures to offset the risk of reckless lending and other pricing, it is likely going to have a positive impact on the economy and benefit millions of credit-impaired consumers. This is our program for today. Thank you to all our guests, McDonald, Neshitenja down in Pretoria and our studios down there, and Stephen Logan, the consumer lawyer seated with me here, answers all the clever questions. And from all of us here in the studio and the rest of the crew, have a good afternoon. Till next time. My name was Dumila Matez.